Hi, I'm Ken Fossen. Today we have a high school principal's question that goes like this. I have a new English journalism teacher this year. Her Journalism 2 class publishes the school newspaper. When I approached her to review and approve the articles for the first edition, she said that I didn't have legal authority to do that. Her words were, students don't shed their constitutional rights at the schoolhouse gate, and they have a First Amendment right to publish whatever they want in the school newspaper, free from your censorship. As a high school principal, don't I have some control over what goes into the school newspaper? Before we review the issue, what do you think? What control, if any, does a high school principal have over the articles that appear in the school newspaper? A, the principal is prohibited by the First Amendment from interfering in any way with the student articles being published in the school newspaper. B, the principal has the authority to prohibit student articles from being published in the newspaper if his or her reason for doing so is based on legitimate pedagogical concerns. C, the principal has total authority over the school newspaper and can deny publication of any article for any reason or no reason at all. This is an issue that most high school principals will face at some point in their careers. Fortunately, we have some fairly clear guidance on this matter from the U.S. Supreme Court itself. Let's take a look at Hazelwood School District versus Kuhlmeier case from 1988. The facts of the case were as follows. The Hazelwood East High School Journalism 2 students published the school newspaper. The principal objected to 2 articles and directed that they be removed from the upcoming newspaper publication. The first article related to 3 students' experience with pregnancy. The principal's objections were first, that although fictitious names were used, other students at East High might be able to identify the students when reading the article. And second, that the discussions related to sexual activity and birth control would be inappropriate for some younger readers. The second article related to family divorce. The principal's objections were first, that the student involved was identified by name, and second, that the parents were not given an opportunity to respond to the student's comments in the article nor consent to the article's publication. When the articles were removed from the publication, the students filed suit in federal district court alleging that their First Amendment rights had been violated. The student's position in the case was that the Tinker versus Des Moines case should be controlling. You probably recall the Tinker case, the one where the students wore black armbands to protest the United States involvement in the Vietnam War. In that case, the Supreme Court held that the school could not discipline the students unless the wearing of the armbands created a substantial interference with the operation of the school. In contrast to the student's position, the Hazelwood School District argued that this case was different from the Tinker case because it was not just a personal matter at issue. It also involved the school's resources, the school's curriculum, and the school's newspaper. Therefore, the school should have more authority to act in this case than the court permitted in Tinker. So what did the court have to say? In short, it sided with the school district. It found the school newspaper was a learning experience, not a public forum. In the court's words, the school officials did not evince either by policy or by practice any intent to open the pages of Spectrum, the school newspaper, to indiscriminate use by its student reporters and editors or by the student body generally. Instead, they reserved the forum for its intended purpose as a supervised learning experience for journalism students. Accordingly, school officials were entitled to regulate the contents of Spectrum in any reasonable manner. It is this standard, rather than our decision in Tinker, that governs this case. Later in the opinion, the court stated, "We hold that educators do not offend the First Amendment by exercising editorial control over the style and content of student speech in school-sponsored expressive activities, so long as their actions are reasonably related to legitimate pedagogical concerns." The court went on to review all of the reasons given by the principal for his decision to pull the articles from the publication and found that all of the reasons were legitimate pedagogical concerns. In its opinion, the court also gave us some other examples of what is considered as valid reasons for censoring articles. Hence, a school may, in its capacity as publisher of a school newspaper or producer of a school play, disassociate itself not only from the speech that would substantially interfere with its work or impinge upon the rights of other students, but also from speech that is, for example, ungrammatical, poorly written, inadequately researched, biased or prejudiced, vulgar or profane, or unsuitable for immature audiences. Further, the court added, a school must be able to set high standards for the student's speech that is disseminated under its auspices, standards that may be higher than those demanded by some newspaper publishers or theatrical producers in the real world, and may refuse to disseminate student speech that does not meet those standards. So given that, is there any limit to the principal's discretion when it comes to censorship of the articles in the school newspaper? Well, the answer is yes, and the court gave us some guidance there as well. It is only when the decision to censor a school-sponsored publication, theatrical production, or other vehicle of student expression has no valid educational purpose that the First Amendment is so directly and sharply implicated as to require judicial intervention to protect students' constitutional rights. So back to our original question. What control, if any, does the high school principal have over the articles that appear in the school newspaper? The correct answer would be B. The principal has the authority to prohibit student articles from being published in the newspaper if his or her reason for doing so is based on legitimate pedagogical concerns. I hope you find this to be beneficial. Thanks to the attorneys at Perry Law Firm for their continued assistance in planning, researching, and writing for these presentations. And as always, thank you for watching, and see you next week.